I will be voting against this very partisan Supreme Court Ethics Recusal and Transparency Act. This bill is not about oversight or accountability. It's about harassing and intimidating the Supreme Court. Over the past several years, the far left has mounted an unprecedented assault against the Supreme Court. The far left is unhappy with the court's conservative majority and detests a handful of its decisions. So the far left has resorted to bullying tactics, even considering that only 9% of the court's decisions last year were on a 6-3 division. The far left's playbook is to attack the court, cast doubt on the legitimacy of the institution, impugn the reputation of the justices, and attempt to dictate the rules and practices of a separate branch of government. Since 2020, we've seen proposals to resurrect the failed, misguided idea of court packing. This is a notion overwhelmingly rejected by the American people when it was last proposed during the New Deal era of the 1930s. Nevertheless, some on the left are actively pushing bills to pack the court anyway. FDR could not do it. How do they think they can do it today? In 2022, we saw the extraordinary and unethical leak of the draft Dobbs decision. This was an overt attempt to ramp up public pressure against the court to sway justices before the final decision was issued. Thankfully, these attempts failed. But the far left continues to deploy extreme tactics to smear the court. Conservative justices' homes addresses were publicly posted and shared. Protesters hold weekly demonstrations outside the private homes of justices in violation of federal statute. Justices and their families have been confronted in public, even at restaurants, and sometimes on vacation. This has resulted in a real physical security concern and at least one assassination attempt. Some of these justices have young children who witness these shocking acts of intimidation. Over the past few months, the latest efforts are to manufacture claims of conflict of interest. At first, there were attacks against the spouses of justices who also happen to work in the vast legal field. However, no such claims were lodged against Justice O'Connor or Justice Ginsburg, whose husbands were lawyers while these justices served on the bench. Now there is a drip of stories attacking the travel of conservative justices. These stories conflate trips from years ago, some decades ago, with newly updated disclosure guidelines announced in March of this year. The rule change from the Judicial Conference is related to personal hospitality exceptions to the disclosure. The judiciary took action on its own to bring clarity to what was once overly broad and poorly defined. These stories cherry-pick travel by certain justices. They go on to raise conjecture and misrepresent the facts and fail to explain the rules that were then in place prior to these March 7th changes of regulations. Remember, many of the events in question took place years ago during the court's liberal majority. Where was the outrage from the left at that time? Were they pacified by the court's more liberal decisions? Or is this newfound ethics focus just simply political smoke and mirrors? Well, the answer is obvious. This is all part of the Democrats' promise made at the steps of the Supreme Court in 2020 to release the whirlwind. On May 2nd, the Wall Street Journal editorial board wrote a great article about this and ongoing political theater. The article correctly notes that so-called Supreme Court ethics reforms is another front to the political campaign to delegitimize the Supreme Court with a goal of tarnishing its rulings and subjecting it to more political control, end of quote. Further to quote, though, the campaign is on full display in the press, with reporters at multiple publications suddenly searching for supposed ethics violations or conflict of interest. The paper writes that writers have examined and debunked these reports. This is a political project, and hyped accusations are going to continue to be asserted as if they are serious, end of Wall Street Journal quote. I'd like to enter that into the record. The far left is now calling for purported ethics reforms and recusal reform for the Supreme Court. Chief among them is this bill before us, which raises constitutional concerns, because Article 3, Section 1, Clause 1 of the Constitution states, quote, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may, from time to time, ordain and establish," end quote. Unfortunately, this bill usurps the Constitution. It presents a clear separation of powers issue. It also calls for various lower court judicial panels to review and rule on the actions of the one Supreme Court and its justices. So, can you imagine? Lower courts established by Congress would be tasked with policing the Supreme Court in ways our founders sought to avoid. In all of the hearings the Judiciary Committee has had on this topic, not one witness was able to articulate effectively how such measures would be constitutionally sound. The CERT Act would create a roadmap for parties to seek out newly defined quote-unquote conflicts and recusals of processes. This could be abused to disqualify justices who may be unfavorable to the far left's view, especially on high-profile cases. This bill, as currently written, risks undermining the independence and the integrity of the Supreme Court. Chief Justice John Roberts, in his letter to Chairman Durbin, dated April 25th, included a, quote, statement on ethics, principles, and practices, end of quote. This statement, undersigned by all justices, reaffirms their commitment to upholding the integrity of the court. So that should also be submitted for the record of this committee. This was signed by all sitting justices. I'd also like to enter, I've already said that. This bill, if enacted, would bluntly insert politics into the Supreme Court and erode away at the checks and balances carefully crafted by our founders. This legislation may needlessly force us down a road towards constitutional crisis. Therefore, I'm not in favor of regulations of this legislation until we know whether the Supreme Court's own actions taken on March the 7th to clarify its disclosures is sufficient. In other words, considering this legislation's probably, even if it should ever be considered, a year or two till we find out how the new regulations work out. Just like each member of Congress and the White House, The Supreme Court ebbs and flows across the ideological spectrum. During the 1930s, scholars have described the Supreme Court as a conservative court. Meanwhile, during the 50s and 60s of the 1900s, the Warren Supreme Court was much more liberal. Someday, this court will shift again. But the actions being considered today are a result of a temper tantrum by the far left. The left dislikes certain recent Supreme Court decisions and are unable to unilaterally ram their policy proposals through the Congress. These efforts to hijack the Supreme Court must stop. Chief Justice Roberts, in his concluding paragraph of Biden versus Nebraska, cautioned against visceral rhetoric and baseless political hits against the court, which has undoubtedly come to a boil in the last several months. So Robert notes, quote, "It's become a disturbing feature of some recent opinions to criticize the decisions with which they disagree as going beyond the proper role of the judiciary. Reasonable minds may disagree with our analysis. In fact, at least three do. We don't mistake this plainly heartfelt disagreement for disparagement. It's important that the public not be misled either. Any such misperception would be harmful to this institution and our court and our country." The end of Robert's statement. Before I yield back, I'd like to enter in the record another Wall Street Journal article from June 21st titled, quote, "Ethics and the Supreme Court Independence," end of quote. This article also highlighted the details, some of the constitutionality, judicial independence, and balance of power concerns of these legislative principles put forth so far. I yield.
Thank you, Senator